Hi, I'm Peter Afrasiabi. The program you're about to watch, Advanced Advocacy, Storytelling and Credibility, was recorded a few years ago, but I've confirmed the content is still current and timely and reflects the current state of the law. I hope you enjoy it. Hello, I'm Peter Afrasiabi, a partner at One LLP and a litigator here in Southern California. Today's program is Advanced Advocacy, Storytelling and Credibility. This program is built around getting to the bottom of some advanced advocacy techniques. This comes from litigation experience, from 20 years teaching my students in my litigation clinics, and from practical nuts and bolts in the trenches experiences, all of which have yielded, we believe, a need to talk more in terms of what are the advanced techniques of advocacy that infect everything that we do as lawyers. So, a lot of programs are built around nuts and bolts, how to do things. For example, how to take a deposition. Do you ask this question? Do you ask that question? Do you use the funnel technique? Those types of techniques. And those are fantastic programs. We teach some of them, and they're very, very important. This program's a little different, though. This program looks at every aspect of lawyering, whether it's taking a deposition, whether it's going to trial, whether it's writing a letter to opposing counsel, whether it's negotiating a deal because you're a transactional lawyer. And it looks at those things we do as lawyers and how we do them in terms of storytelling and credibility, which are the two polestars that attach and infect really and bleed through everything that we do as lawyers. So I'm going to talk about storytelling and credibility as these two polestars. They're sort of stakes in the ground that everything revolves around. And in talking about storytelling and credibility, we're going to walk through a lot of fantastic, fun examples, and we will then hit some real-world examples from some real-world litigation. A famous case that went on during the Cold War in terms of a deportation battle with some really excellent material to look at to explore storytelling and credibility. And we're even going to travel back in time to ancient Rome, to the Roman Republic, and even the Roman Empire, and look at where these principles of storytelling and credibility come from and how they've traveled through time and they're still relevant today. So let's get going. You can see here on the first slide the bullet points in terms of what we're talking about as I just ran through with you. And what we're going to look at is the effective use of these techniques today in lawyering and how you can do them. So, what are these two polestars of storytelling and credibility, and where do they come from? You see here, there's a great picture of our ancient Cicero, who is one of sort of the greatest orators and lawyers from history, whose principles live today, whose works live today, and we can read them. And his work, De Oratore, is translated on the ideal orator. And here are sort of 5 basic principles that distill from Cicero's work. And these principles are principles that we use today. We've all learned them as lawyers, and they're valuable and important. And I want to give you these principles first, and then talk about where we get storytelling and credibility out of these principles. So the first one is knowledge. Basically, this means know the law you're dealing with and the facts in your record. You need to show up aware and understanding of the broader ecosystem of your legal claim, what it fits into in terms of the legal regime, the broader social regime it may be fitting into, and you need to know your facts in your record. That is sort of the basic root necessity to show up and be an advocate in any context. And if you don't have that material, you won't be able to craft your story properly, and you won't be able to maintain your credibility as an advocate for your client. The second point is word choice and arrangement. Use your words carefully. Don't oversell, don't overstate. You want your advocacy to be persuasive. This is a very, very important lesson that runs through all advocacy programs, and you'll see it pop up several times today. It's one of those sort of threads that weaves through everything. And it's very, very important to be cautious and judicious with our words, because it's so easy as lawyers when we get animated and we're moved by our case, we believe in our case, to very easily cross over lines of almost rationality and start saying things that aren't sellable, aren't believable. And at that point, once we are overstating or overselling, we are losing our audience often, and that's a big problem. Third point, emotional knowledge. Word choice has to appeal to the right emotion, to explain, to justify, to dispute. But to do this, you have to be aware of the emotional impact of your words. In other words, the audience issue. Bad words can hurt a good point. You can lose your audience by having the wrong emotional knowledge about what it is you're doing. And so, for example, when you're speaking to a jury, the pitch at which you may be talking about the emotional impact of the facts in the case and what a jury should do will be different to when you're arguing a summary judgment motion before a judge. And that will be different yet again to when you are arguing on appeal before three judicial minds who the audience for which is focused on very different legal issues. So being aware of your audience and setting your pitch to the right audience is absolutely critical. The fourth point is facial expressions have to be used effectively and appropriately to persuade, not to overstate, not to anger, not to upset people, nor to be indifferent or boring. And so this is something that's very important in terms of when you're arguing cases, for example, and you're sitting before a judge, you will sometimes see in oral arguments lawyers frowning and raising their eyes and gesturing when the other lawyer is speaking. And the lawyer making those gestures is signaling to the judge on the other side, oh, the absurdity of what you're saying. Oh, it's ludicrous. It's not believable. That type of behavior is distracting and regularly upsets judges. That doesn't help your cause. You can make the point that what they're doing is ineffective in different ways, but telegraphing through wild gesticulations and emotions to the court is inappropriate and unnecessary. And what it does is it hurts your client, hurts your case, hurts you as an advocate. The fifth point is voice inflection and tone to emphasize. And this is something that Cicero, of course, focused on more than we do today, perhaps, because in Cicero's era, sort of all advocacy was of an oral nature and was heightened. There weren't written summary judgment motions, for example, where, whereas we worry about punctuation and nice rhetorical flourishes in the written word that isn't heard all the time, in his world, everything was heard. And so voice inflection took on an even more important role. It's still important today, however, to know when to inflect your voice and when not to be comfortable with silences, to pause when necessary, to move fast when necessary, or to move slow. So those are some of the five or six cardinal principles that come from Cicero. And so what distills out of all of those principles is this idea that what we are getting to is storytelling and credibility. These are what you need to wrap yourself in. You see Cicero there in the picture wearing his toga. We as modern lawyers, we may wear our suits, but what we really need to envelope ourselves in is credibility and the capacity to tell a good story in all aspects of our case. Let's look at the next slide. We're now going to start talking about storytelling. What is it and why does it matter? Once upon a time. It's an incredibly magical phrase, isn't it? It conjures up feelings and emotions and ideas. It's a phrase that, it turns out, exists in many, many languages, and it's been used for thousands of years across cultures and language. You see here, mukashi mukashi. That's the Japanese phrase, long ago, long ago. The phrase itself, if you stop and think about it, doesn't impart any particular meaning. That's not what makes it magical. In other words, you could not say once upon a time. You could tell the story that comes after once upon a time, and no meaning would be lost. The story is what it is. But once upon a time as a phrase is magical because it tells people and it signals people a story is coming. Now, we use variations of this even today. You see here on the slide, a long time ago in a galaxy far, far away. The opening line in Star Wars. It's powerful. It conjures up feelings and emotions because a story is coming. Or in music, a long, long time ago, I can still remember. My voice is no good, obviously, but you get the point. It takes you somewhere as a listener, as a reader. Now, for thousands of years, before George Lucas or Don McLean's American Pie song, people have told stories. They've told stories to teach, to share values and ideas, and to persuade. Stories are the most powerful, useful vehicle to persuade. So, we as lawyers have to understand the art of storytelling. But something happened to us when we went to law school. Our law professors, the legal profession. The legal profession does an incredible job in law school at destroying the storyteller in us. Law school is built around causes of actions, elements to prove, claims to make, defenses to make, whether something meets an element or does not meet an element. Lots of theoretical exercises about standards. And all of that is the framework that we are given. And that framework is often divorced from the art of storytelling. How do you engraft a coherent story onto those elements that are obviously important because we all have standards to meet in our cases, but we want to win our cases through storytelling. And the framework of elements and causes of action from law school isn't really the framework of stories. And so that's, in many ways, the first time that for us as lawyers, I think in the legal profession, the act of storytelling is almost beaten out of us because of the experience of law school. And so this program is a fantastic way to recontextualize, to think about those things that have subtly been drilled out of us as lawyers in our training and in what we do. So let's get moving along to the next slide. Logic and emotion. You see here a quote from Cicero. To prove as a matter of necessity, to please through the exercise of charm, and to move as the source of victory. That's a quote from Cicero, De Oratore, on the ideal orator. To prove, to please, and to move. Those are the three legs of the stool from antiquity in terms of what it took to be an effective advocate. And those three legs still exist today. We need to please, we need to prove, and we need to move. Now, modern advocacy techniques in law school and what we do as lawyers day to day really has a heavy emphasis on the first element there, to prove. Logic. We're very, very good at using logic. A plus B plus C equals D for the cause of action. If you don't have C, but you have something close to C, is it enough to get over the hurdle? What is the difference between a preponderance of the evidence and clear and convincing and beyond a reasonable doubt? Is it a sort of a mathematical formula, 51%, 75%, 98%? We are trained to think in terms of logic, in terms of how we move our cases forward. But to understand storytelling as a powerful, transformative act for a persuader here, let's look at how master communicators historically have used stories. And you see here on this slide some obviously famous people from history, and we can go any number of directions really with this. After all, 7 years ago, what is that? That's simply an antiquated and highly stylized way of saying, once upon a time in 1776, etc., etc. Or Martin Luther King Jr.'s I Have a Dream speech. It was intended to be a continuation of Lincoln's story, beginning with similar language. 50 years ago, a great American. Again, storytelling to go back. We can even go to Kennedy's inaugural address, President John F. Kennedy's inaugural address. It was a story of a new generation of Americans carrying on the founders' commitment to liberty in a new time against a new threat. So, many of the great speeches, many of the great efforts at persuasion are stories, and they use stories to achieve an end. And for us as lawyers, our whole goal is to achieve an end for our clients, to win a case, to win a negotiation, to achieve a goal for a client, whether it's an individual, an artist, an inventor, or a business in its needs. We need to achieve an end, funneling through the legal prism of causes of action and defenses and claims and rights, stories. So, the transformative nature of stories is about explaining and connecting rules to persuasive reasons for rules. This transforms the harshness or the seeming arbitrariness of rules that are necessary to make them proper rules that are important, that you can embrace. Storytelling serves this bridging function that's so critical to advocacy and to persuasion. So let's take a quick meander back in time to look at the transformative nature of stories and how they can be used to bridge divides that seem unbridgeable in terms of the legal regime one confronts. And so, of course, since I've mentioned Cicero, we're going to go back right now to the Roman Republic, to Cicero's time. And Cicero, of course, was one of the great orators from history, and there you can see him. And he made his reputation and he began his path to the consulship of Rome by prosecuting a corrupt Roman official, a senator named Verus. Now, the case against Verus was strong. He was greedy, corrupt, and violent. Cicero's problem, however, was that he had to convict a Roman patrician before a jury of Roman patricians, senators, that this man was corrupt. And in reality, Cicero confronted a legal regime where there'd been only one such conviction in the decades, maybe even century before, even though corruption was, of course, prevalent. Now, this particular defendant, Verus, had a lot of powerful friends. He had an army of lawyers on his side, including at the time Hortensius, who was really considered the greatest advocate in Rome. He was also a newly elected consul himself. So, all of those were the headwinds that Cicero confronted. Deeply connected, rich, powerful man with great lawyers and his own cronies making up the jury. This problem for Cicero had to be confronted and bridged. How do you do that when you confront a system like that? How do you tell a story that can pierce through the very, very difficult legal headwinds that you confront because of the practical realities? Cicero did it this way. He told the senators that basically no one believed it was possible to convict the rich and powerful in Roman courts because the senators and the entire judicial system they oversaw was corrupt. And so what he said is, this case, what's at stake is proving to the people of Rome that the system's not corrupt. People who say the system is corrupt, they're wrong. You're capable of proving that you're not corrupt. You're capable of applying the law dispassionately and finding someone, even someone from your own ranks, who's guilty. So here's what Cicero said. For an opinion has now become established, pernicious to us and pernicious to the Republic, which has been the common talk of everyone, not only at Rome, but among foreign nations also, that in the courts of law as they exist at present, no wealthy man, however guilty he may be, can possibly be convicted. Cicero was telling the system, the jury that was confronting this case ultimately, that they were under scrutiny and that Roman justice, this ideal that the world knew about and respected Rome for, it was at stake, it was on trial. He said, this is a trial in which you will be deciding about the defendant, the Roman people about you. By the example of what happens to this man, it will be determined whether, when senators are the judges, a very guilty and a very rich man can be condemned. That's the story that he told. That was how he pitched this case. Not the element of, under Roman law, it is an act of bribery to do X. This man did X, therefore he should be convicted. It wasn't the logic of the law. It was a story in which that logic of law could be grown. It was the ecosystem for the story. What happened? The appeal worked. The previously confident, and criminal Verus fled Rome. Cicero won, went on to become really the greatest orator of the ancient Republic word. So that is a perfect example from antiquity in terms of the use of stories to funnel a legal case through the right prism to be effective. Let's go to our next slide. Storytelling doesn't begin at trial. It begins in the beginning of a case. And so here we'll talk a little bit about the act of building facts. How do you build facts to make your case? There's this art to building facts, and it's built around recognizing that you should not be chasing conclusions constantly. And so let's talk about this a little bit first in one area that we as lawyers find ourselves, and that's in the realm of discovery. In discovery, we take depositions, we serve interrogatories, we gather information. And what we often do is develop our narrative and our belief about what our case is about, and we don't listen to the other side. We're very good at pounding our chest about our side and about how the other side is wrong, meritless, frivolous, ludicrous, you name the words, right? But we don't listen properly always. And listening to the other side very carefully is a critical skill. that is used in order to build facts and avoid getting trapped into chasing conclusions that maybe you cannot reach. This requires us to be willing to embrace uncomfortable facts. Don't run from them. You need to know what you're confronting. Now, trying to get conclusions without facts always creates wiggle room for a witness. But if you focus on the simple facts and you nail them down, it leads to the inescapable conclusion, even if the witness won't agree with you on the conclusion. So let's look at this. Because conclusions in reality are hard to get, you need to focus on the facts. Now, the witness may not know much, but they generally know that agreeing to your demand for a conclusion is a problem. And this can be because the witness can tell that the conclusion is terrible. So take something simple, for example. This fact pattern where Sally has dropped a plate, you see here on the slide. That's a fact. You can get Sally to agree she dropped the plate. Now, if your claim hinges on proving that Sally was grossly negligent or reckless or willful, hammering Sally on questions such as, "You were reckless, wouldn't you agree?" is never going to work. The witness is not going to concede, even if the witness isn't particularly smart. They will know enough to know that's nothing they can concede on. So they'll fight with you, they'll spar with you, and you'll fight with them, trying to convince them and prove to them in a context of perhaps taking a deposition that they were reckless. And in the process, you may miss all sorts of basic facts. What exactly did Sally do? Was she carrying the plate with one hand, with two hands? Were her hands wet? Was she carrying it on her head? Was the floor wet? Did she slip? Was she carrying a knife at the same time? Whatever the facts may be that you need to get out, if you get the facts out, it can inescapably lead, as you build fact after fact after fact, to the conclusion that of course Sally was reckless. She was carrying the plate. Yes. Were your hands wet? Yes. Were you wearing gloves? No. Did you see where you were going? No. Was the light on? No. It's inevitable then and now that Sally was reckless. But if you hammer her on, you would agree you were reckless, won't you? You will get a witness who doesn't agree with you. So let's stay focused on building basic facts, because that lets you tell a story. Now, one of the important points is to distinguish between conclusions and facts. Conclusions deduce from facts. The facts, though, let the trier of fact deduce that conclusion. So let's just keep those two concepts distinct. The next part of storytelling, as you see on the next slide, is character development. We read books, we watch movies, we love characters. Characters move us. We, in our cases for our clients, need to tell stories built around our characters. Who are our characters? We have our antagonists, our protagonists, our third-party witnesses who are bit players, perhaps, to the drama that's unfolding. But we need to understand these characters in our cases as three-dimensional beings. They're not just good or just bad, the way we are trained in litigation to position our cases. And this requires us to have a dispassionate eye, a very dispassionate, acute eye. How will a jury see your client versus how you see your litigation adversaries? So, your client may well see the adversary as evil, terrible, maniacal, bad, nothing good about him. And that's the argument that your client's paying you hundreds of dollars per hour to pursue and to prove to a jury. And it's very easy to get caught up in that as lawyers. I mean, we answer to our clients, after all, they pay our bills, and we want to do a good job for our clients. But we have to maintain an acute, dispassionate eye. We have to recognize that it is the most incredibly rare case that ever finds its way before a jury, where you have only good versus only evil, right? People are complicated, issues are nuanced, and you need to be willing to take that acute eye as you build your character development and truly understand the other side. And if you enter, for example, a deposition of the opponent with the perspective that they're just evil per se, and I'm going to try to get a bunch of conclusions to prove it, you're not going to get anywhere. You need to understand who these people are as human beings. Why did they do what they do when they made the decisions they made that are relevant in your case? You need to unpackage that to understand when they get up and project themselves, what will they project? How can you take that down? This is what we mean by understanding everyone in your case is a rounded three-dimensional character. And it's also why you just can't rely on your client. The other component to this, and this is sort of the critical corollary, is that you cannot, in the beginning of a case, just assign a role to someone and let that character have that role. This isn't, for example, a book that you're writing. If you're writing a book, you can decide that character 1 is going to be good and character 2 is going to be bad. But in a litigation, you don't get to just say the other side's bad and I'm good. Neither does the other side get to do that to you, right? You're dealing with a set of materials that exist out there that can be discovered if you do it properly, that can be mined if you do it properly, to build the characters in the way that fits, and to find out what you can build and what you cannot build, so you know what kind of characters you're dealing with and you're working with to be able to tell a story effectively. Now, we frequently try to assign roles to our witnesses and the other side's witnesses that they just can't play. The first time I ever saw this, it was a big civil trial my partner Chris Arledge and I did, and it was our first big trial. And we've been practicing law sort of 5 or 6 years, but it was our first case where there was 10, 20 million on the line. And we were defending a big company. And this big company had been bought and sold 5 or 6 times, and that probably candidly explains why 2 young lawyers like us were trying a $10, $20 million case for them. But it was a fantastic experience, and it was thrilling. What we learned in that case was the other side just thought they were going to get $10 or $20 million. And the whole case was about whether someone was a superstar salesman. And their pitch to the jury was that their guy was Superman, the Hercules of sales, best thing since sliced bread. And they needed to win that pitch in order to get the $10 or $20 million. I mean, this guy needed to be Top Gun Maverick, right? That's who he had to be. And that was the pitch they made to the jury and they pushed. The problem? The facts just didn't support it. And we understood that guy from deposition testimony and from documents, and understood that he was a nice guy. This guy wasn't Maverick, and there was 101 reasons why. And so when they got up and they said that, hey, look, I got Tom Cruise Maverick here, that's who he is, we were easily able to show, no, you don't. That's not who he is. And so that lesson is, you can't make someone be someone they're not. Even if that's who you need to get $20 million, but you don't have it, you can't bridge that gap. You don't have a $20 million case, it turns out. And they didn't, nothing close to it, it turned out. Great experience to understand the reality of being able to work with the characters that you have and make them fit the puzzle. Don't make the puzzle fit them. Now, let's move from storytelling to credibility. Here on the next slide, we're going to start exploring credibility. What is credibility and why does it matter? There are hundreds of different aspects to lawyering, as we all know, of course. We write letters, we engage in discovery, we take depositions, we write mediation briefs, we write motions, we argue appeals, we negotiate with adversaries in transactional deals, we negotiate with government agencies to get rights for our clients or grants of patents. You name it, hundreds of different things that we as lawyers do. But all of them are imbued with the same necessary attribute of credibility. And so here's how I like to think about it. This is the analogy that I always give my students in my litigation clinics, and this is how I talk to my young associates at my law firm about it. When you think about, you go into Home Depot and you look at all the tools, right? There's a hammer, there's a saw, there's a drill. There's hundreds of different tools. I don't even know them all. But each brand, for example, will have the same color coding across all of its tools. And so you'll see the familiar dark blue tool with the orange handle. And that'll be on every single tool that company makes. And that color coding functions as a trademark in a sense, and as a brand. Every tool, regardless of what function that tool is achieving, is imbued with the same idea concept, that blue and yellow or that blue and orange color coding thing that denotes a brand. The same is sort of true for all of the different things we do as lawyering. And that brand that attaches to all of them is credibility. You can't see the color. It's not like we wear red ties all the time in everything we do to telegraph it as a trademark. But you should think about everything you're doing as a lawyer that's enveloped in credibility. Credibility is critical. So Cicero said, "All my efforts are always concerned with this goal, for I will say it again and again, to do some good by my speaking if I can, and if not, at least to do no harm." This is a way of expressing and understanding credibility. We want to help with what we do, but we don't want to harm our clients. We want to have character and honesty and have everyone recognize that we have character and honesty and that we're trustable. That's where we build credibility. And if we say things that harm our clients because we oversell, overpitch, we lose credibility. And so this is tip 1 here. Overselling or overstating things can really damage your cause for your client. And often it's driven by a desire to act, to do something, right? We're lawyers, we pound our chest, our clients are paying us a lot of money, they expect us to do, to perform. And so we can very easily slip into overselling. And one of the common ones are the words that you've probably heard from many, many judges if you've spoken to judges, or if you've sat and watched loads of oral arguments or participated in them, you will have seen courts regularly stop a proceeding when one of the lawyers says something like the other side's argument is disingenuous or outrageous or frivolous or clearly absurd. Phrases like that. You'll see a court pause the proceedings and use it as a teaching moment for not just the lawyers before them, but for the entire courtroom on the oversell, the overstate. And at that point, you've been beaten back into your corner as a lawyer. You've been shown to have overstated something that you can't sell, and you've lost your credibility. This goes back to the word choice idea, right? But Cicero's do no harm mantra, still very important. Here's another thing that's critical really for lawyers, and this is credibility by concessions. Yes, making concessions can build credibility. One of the problems we confront as lawyers is this unwillingness to ever accept defeat on anything. And so we fight on ground that you can't win on often because we just don't like giving up on anything. And what we've done by doing that is we've not made a concession, and we've not seen that concession can actually be positive. You don't want to make weak arguments just because you fear conceding points. Better advocacy is often not more arguments, but less arguments that are done right. And so here again, let's just pivot back to law school. Just remember your first year torts exam, right? Some crazy hypothetical fact pattern of all this insane stuff going on. And you looked through it and you had to sort of analyze every possible cause of action that everyone had against everyone. And if a monkey fell out of a tree and landed on someone, and they got hurt, that was part of your tort exam. The student who explored whether you could sue the monkey for battery and then concluded maybe you can't, that student got extra credit from the professor. They did better because they were hyper creative. And the person that looked at it and thought, sue a monkey? It's absurd. Lost some points. And so what we learned in law school is come up with every idea under the sun, analyze it, and that's the best thing you can do. That then, as we become young litigators, leads people to have a simple case between someone punching someone and they come up with 19 causes of action that you see all the time. It is not better to make more arguments always. And that aspect of law school and young lawyering sometimes doesn't get focused properly and people end up overstating claims. So you can gain credibility by making concessions. This is true in briefs, in motions, in negotiating with people on the other side of transactions. If there's something that's weak on your side, you can accept it, you can concede it, and then you can give back on another point, and you can buy credibility with a concession. And so when you see the final bullet point here, I really mean it. You need to see concessions as gifts. These are opportunities. You make a bad argument and give up a chance at a concession, you've blown your credibility. A good concession lost is a gift lost. Yes, as you see on the next slide, I really mean it. Concessions are gifts. There's a great book written by a man named Cialdini called Influence. And he looks at reciprocity studies, and he looks at really how human beings feel an obligation to repay a gift that's given to them, even if they never asked for the gift in the first place, and even if they didn't want the gift. That's a massively important point. We use that point in lawyering and advanced lawyering skills when we're speaking to juries, the other side, or to judges. And you have to understand this cardinal principle of reciprocity. And if you haven't read Cialdini's book, Influence, go read it right now, or at least after this program. It's an incredible book that gets you thinking about these principles as valuable to us as advocates. So concessions trigger obligations. And in the book, Cialdini talks about a story, and it's a great story. He talks about how a Boy Scout approached him, wanted him to buy some tickets to some event. And Cialdini didn't want to go, and he told the Boy Scout, "I can't go, I'm not available." And the Boy Scout said, "I totally understand if you can't attend the event, but would you buy a couple chocolate bars anyway to help us in our fundraiser?" And Cialdini bought the chocolate bars. He asked himself later, why did I buy those chocolate bars? I don't even like chocolate. The answer, he concluded, was the Boy Scout conceded that he didn't need to worry about the event. And that concession that don't worry about the event, that was a gift. The event doesn't matter. The Boy Scout gave him that gift. And he, in turn, felt obligated in this act of reciprocity to give something back, so he bought a couple chocolate bars that he didn't even want. It was a gift he subconsciously felt the need to pay. This is a very, very powerful story to illuminate the idea of concessions and how they can be used, sometimes very, very subtly, to gain currency and favor for yourself. Let's now shift to an appeal, for example, and look at credibility on appeal, assigning error, and more importantly, not assigning error. Here's a quote from Supreme Court Justice Robert Jackson from the 1950s. "Legal contentions, like the currency, depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed error. But receptiveness declines as the number of assigned errors increases. Multiplicity hints at a lack of confidence. Multiplying assignments of error will dilute and weaken a good case and won't save a bad one." On the next slide, you can see I call it the currency of credibility chart. This is a critical chart, and there's an inverse relationship fundamentally between the number of assignments of error and the audience's receptiveness to the idea that an error occurred. If you're saying, for example, to an appellate court that the lower court, on my chart I picked the number 10, it's arbitrary, but they did 10 things wrong, there is a very low receptiveness from your panel to the idea that they really did 10 things wrong. But if you're down at, in one or two, they made one or two mistakes. Human beings make mistakes. There's a willingness to entertain the idea that they made mistakes. In other words, you can't sell effectively the idea that someone is a complete idiot and can't do anything right when they're outperforming their job. You need to be judicious in your assignment of error. And this goes back to one of Cicero's precepts about knowing your audience. Now, the next slide is titled "The Messenger Matters." What does this mean? You're the messenger, and emotion is critical to use carefully and properly to win your arguments. If you have a bored decision maker, whether it's a judge or a jury, it's a disaster for you. Now, don't let yourself be misled. Delivery cannot substitute for substance. You can't just get up there and be the flashiest speaker where the words coming out of your mouth are nonsensical and there's no substance or no logic or facts to back them up. But substance alone can't be the end of your advocacy. And this again goes back to the law school problem of A plus B plus C equals a battery, therefore you win. That may be true, but your advocacy cannot end just on that substance. It needs to be built with stories. How do you, as the messenger, matter? Well, you have to connect with your audience. How do you do that? You have to be yourself. I put it in bold because I think this is one of the most critical and misunderstood ideas for us as modern advocates. Be yourself. Fake acts to be what you think people perceive you should be, or lawyers should be, because we've watched A Few Good Men and we've seen Tom Cruise pounding the table, or we've watched Perry Mason and we think that's what we need to do. That backfires if you're faking who you are. You have to be yourself. You've got to be comfortable in your own skin. Why? Because people will see through you if you're acting. Be yourself. Have you ever stopped to wonder why you see regularly the most incredibly talented, successful lawyers, and they fit all versions of people? You have powerful, strong, pound the table men and women. You got the folks from Texas with the hats who are the trial lawyers, but you have the folks from the Northeast or from Florida who fit a completely different profile. Any and all profiles can be highly successful lawyers. They are because they're comfortable in their own skin. They're not faking it. So you can't show up and suddenly put on a Texan drawl in front of a Texan jury and do the swagger that a local guy can do because that's him. Juries see through it all the time. Now, I think one of the reasons public speakers fail regularly is that they seem inauthentic precisely because they're afraid. They're afraid to mess up. They're afraid they're going to be judged, and they're afraid to be themselves. So they build up these walls to create personas to be someone else, someone who they're not. And that is, in effect, that building of walls is what walls them into defeat. So they don't become comfortable with who they are. They're focused on what they think the audience expects or wants rather than who they are. They use different vocabularies and gestures. They look at their notes. They'll even look at the foreheads of the audience rather than the audience in the eyes. All of this separates you from your audience. You can't connect with your audience. You can't be charismatic unless you break down those walls. Be who you are and only who you are. Don't be afraid to show emotion, but don't ever fake that emotion. Jurors and judges see through it all the time. You got to be yourself. Now, let's pivot to some storytelling and credibility from a real-world case. And this comes from the Harry Bridges cases. And there you see, I've actually written a book on it. So this is the shameless plug for the book. But it's the true story of the longest deportation battle in American history. It had multiple cases. And it's got incredible litigation lessons in it for us today in terms of advocacy, in terms of storytelling and credibility. And the story is set in the 1930s in the Great Depression. There were waterfront battles between labor and employers. And it's just this explosive area. And in this explosive setting, Harry Bridges was a longshoreman, and he rises to prominence, leading the longest strike at that time in American history, a full strike that was a literal general strike that shut down San Francisco for a while. And all of this led to him being put into deportation proceedings because he was alleged to be a member of the Communist Party. He was from Australia originally. And at the time, that was a deportable offense. And it's really a sterile legal question in the very first case. Was he a member of the Communist Party? If he was, he could be deported. If he wasn't, he couldn't be deported. So let's take a look at this first trial that was in administrative court in 1939. This is in San Francisco, and the case had all the drama you can imagine. It had lawyers running with Al Capone, being government witnesses. It had convicted murderers being pressured to convict Harry Bridges. It had people being pardoned because they were been framed, assassination attempts, perjuring witnesses, you name it. It's incredible drama. But it's in this first trial that we can start looking at some very specific examples of storytelling. And we start in the very, very beginning, the opening statement. So let's look here on the next slide. This is the government's opening in the case of INS versus Bridges in 1939. And there is an actual copy I reproduced from you of the actual trial transcript. It's original crinkly old paper that I got from the National Archives when I wrote my book. And you can see the government's opening here. This is what the government tells the fact finder. We shall offer first, for the consideration of opposing counsel and for your honor, the affidavits which are the basis for the issuance of the warrant. We shall then interrogate the persons whose affidavits are made, and we shall thereafter give, of course, opposing counsel the opportunity to cross-examine. Thereafter, in due course, we shall produce other witnesses whom we believe will elaborate, confirm, and corroborate the testimony of the original affiants in establishing that the alien charged is within the meaning and purview of the deportation laws and therefore should be deported. That's it. That's an IKEA manual of an opening. We shall put on evidence. The other side shall cross-examine. We shall show you that A plus B plus C equals D. It's an IKEA manual. No story there, no broader context. Let's go to the next slide. Here's the defense opening. And this was put on by Carole King. Now, before we had RBG, we had Carole King. Carole King was one of the founders of the National Guild, famed civil rights lawyer in the 1920s and 30s into the 40s, and sadly died very young. But she came up in an era where very, very, very few women were ever in the practice of law. Her brother was actually the founder of the Paul Weiss law firm, that's still around today, the mega law firm out of New York. And she was a firebrand of a lawyer, an incredible advocate and lawyer. And so the government did their opening, and here's Carole King's opening. It's our contention that the unusual character of this case to a large extent will determine the character of our defense. Since 1934, Harry Bridges has been a stormy petrel around whom has raged such a storm on only the most violent labor struggles engender. He has become such a symbol of labor strength to certain employer groups that they have spent and continue to spend large sums of money to get rid of him. This case is a product of employer plans and employer money. Just stop and think about that. We now understand her story. There's no truth to this case. It's a setup by the employers who want to get rid of a powerful union guy. The story continues. We shall show that shortly after this time, the forces trying to get Harry Bridges began to use different methods. They began to offer large sums of money for affidavits against Bridges. They resorted to blackmail of those facing long terms in the penitentiary, offering freedom in exchange for an affidavit that would place Bridges in a communist, and we go to the next slide, party meeting. We shall show further, you see here on the next slide, that the people who sought the impeachment of Secretary Perkins were the people who sought the deportation of Bridges, procured evidence, and even prepared the case for the department. One of these people is Harper Knowles, but the mainspring of the whole conspiracy is Doyle, who has supported himself by this case for several years. It is he who does the dirty work in perjuring witness, is so that Mr. Bonham's hands may remain clean. A powerful story explaining that we're going to show you there's been a bunch of murder in terms of the framing of Harry Bridges. Murderers, assassination of witnesses, all of this stuff has happened in order to get this guy. And so this is not a sterile case about whether someone is a member of a party. It's about whether someone is being framed to be a member of a party to reach a different end. That is an opening that tells a story. And think about what she said to the finder of fact she was going to do. She specifically said, here's what I'm going to prove to you. I'm going to show you that there's been perjury, there's been affidavits given that are false. There have been even the government lawyers have tried to get rid of their own boss, Secretary Francis Perkins, from the INS. We're going to show it all to you. It's a big deliverable, and as you see if you read the book, she delivered and showed it. So now let's take this idea of storytelling, and let's go to the next slide. We're going to look at examining witnesses and the emotional appeal of witnesses and how you can use them. Here's a fascinating part of the case. Harry Bridges needed to win in part by putting on his case using witnesses who were convicted murderers in San Quentin. I mean, these are not people who generally have credibility right before a jury. These people are convicted murderers. They're on death row. But they actually were central to the bribery operation. And so you see here, using the emotional appeal of a witness properly. And the lessons you get when we look at this snippet are, let the witness speak. Let the record unfold. Don't interrupt at a certain point that's obvious. Let that record be what it is. And so you see here, the background I'll tell you real brief is that these folks convicted of murder on death row testified that the government lawyers had come to them and had basically offered them, we'll get you from the governor of California a pardon. Just say you saw Harry Bridges at some of those labor, Communist Party labor events. These people actually said, we didn't even do anything. We've been framed. We never murdered anyone. Our whole conviction is a sham. But they were being offered their freedom if they just pointed the finger at Harry Bridges and put him at a Communist Party meeting. Harry Bridges took the trial to the prison in order to have these people testify. And you see here then the tail end of the testimony when the witness had been asked, tell me what happened. And the narrative unfolded. And the witness was then told the story about how he had been offered bribery and was asked, why didn't you do it? Why didn't you take the bribe? What did you say to the government lawyer? And the witness says, well, what I told him was, I'm about 45 years of age. I've been to a lot of places and done pretty near everything I wanted to do. Had a good time and had good friends too. Nobody can make me perjure myself though. And then you see in the court reporter transcript there, it says, witness visibly moved and sobbed audibly. The lawyer then says, for Harry Bridges, Mr. Grossman, may we have a recess for about 5 minutes? And the judge says, yes, recess. Powerful testimony. Convicted murderers sobbing on the witness stand saying they're not willing to trade their freedom for their word because they have character. That was a powerful story that came out and was allowed to come out. And note what else happened. The court reporter took down the witness was crying. Rather than keep going with questions, the lawyer said, can we have a brief recess? It was a powerful way of marking that this is a significant event. Let it sink in to you, the fact finder, by taking a break. And the court said, yep, let's take a break. So now let's move to the next slide you see here, and this is just simply the fact finder's conclusions on that. And the fact finder, ultimately said here that, as you can see, that this is literally pasted out of his decision that, these people were eminently believable, and it's really unbelievable what had happened in terms of the government lawyers trying to, strike a deal with them. And by the way, one of the government lawyers that did it was sitting there watching the testimony unfold. Didn't say anything, didn't even get on the witness stand himself to dispute the story. They were believed. Now, let's go to the next issue of looking at some of this stuff through the lens of cross-examination. storytelling and cross-examination. A basic critical point here is that simple basic facts can imply powerful conclusions. And so what do we have? In the broader context of this case, we have the government needing to prove Harry Bridges was a Communist Party member, and they needed documents or witnesses, someone that would place him at Communist Party events. Now, the INS had investigated it for years and had found absolutely no evidence that he was a member of the Communist Party. But the government lawyers on the West Coast suddenly had this key witness, government witness, and it was a union lawyer named Cicero. And he was put on the witness stand, and he credibly testified. He was a lawyer, reputable guy, that Bridges had admitted to Cicero that he'd been a Communist Party member, and that Bridges had said, "I can destroy anyone with the Communist Party's help in 24 hours. This suddenly was firsthand testimony from a lawyer that Harry Bridges was an admitted member of the Communist Party, and the government then put this testimony on, and they finished on a high note on their direct testimony. Let's look at cross-examination and how you can use basic facts to imply powerful, powerful conclusions on credibility. We see on the next slide, we have basic facts, and this is by Mr. Grossman, one of Harry Bridges' lawyers, where he says, "Mr. Cicero," and this is how the cross-examination starts, "I'm going to show you what purports to be a certified copy of certain proceedings in the district court for the Southern District of New York, and ask whether this disbarment I show you is the indictment you referred to in reference to the indictment of yourself in that court." Cicero looks at it and says, "It is." Then the lawyer says, "I will ask you also to examine this petition and tell me whether that is a petition which was the beginning of the proceeding which resulted in your disbarment in that court. That is the petition." That is powerful stuff, because what it shows is Cicero's credibility has now been blown up. All of a sudden we've learned he was disbarred by a court for dishonesty, and it goes on, so let's keep going. The next slide you can see on our page 22 here is the following, where what the court had said about this lawyer witness who is reputably carrying the government's water is, notwithstanding his obligations as an officer of the court, Cicero was willing to have his client become the beneficiary of whatever advantage might accrue to him through co-defendants' unlawful activities. He was content that justice should be improperly influenced, if not polluted at its source. This was a case of jury tampering, where Cicero ended up being disbarred from the Southern District of New York for being involved in jury tampering. So you can see he's going downhill, and he's going downhill fast here. And on the next page, you can see now we have some questions. I'm going to direct my attention now to this indictment of yours in Chicago. Now we're shifting from being disbarred in New York to an indictment in Chicago. The date's 1934, is that correct? No. What was the date? I think it was 1933. We now have testimony unfolding on these basic facts that not only had he been disbarred, he was indicted. You can imagine the fact finder's eyes popping up saying, okay, now I can contextualize this witness in a broader story. What was this about? Well, isn't this indictment related to a charge of conspiracy to stifle trade by bomb making and acid throwing? Yes, it had a great many things in it. And then you see the next snippet down from the transcript. You don't know some of the other defendants, do you? And he says, yes, I remember some of them that were named and not served. For example, Al Capone was named and served. And so now we got a witness who literally had been indicted with Al Capone. And so this is sort of powerful evidence in terms of storytelling and using basic facts to get to, powerful, powerful conclusions that you need. And so you see now on the next slide here, number 24, the question was, you want the record to show you don't care to reveal the names of the two representatives of the Dies Committee with whom you discussed the question of your testifying before that committee. Is that correct? I don't think that's a question you asked. I'm asking you another one now. Do you care to answer it, please? Give me the question again. You want the impression left here and in the room that you, and then the witness is now yelling at the lawyer now at this point. Don't yell over me. Do you understand, Mr. Gladstein? Don't yell at me. And then the judge is now telling the lawyer, Cicero, one moment, Mr. Cicero, we're not going to have an altercation here. And then as the testimony goes on, it's kind of remarkable when you see the record, if you read it fully. At one point, Cicero starts objecting to the questions himself, and the government lawyer's not even objecting. And so this smooth witness was completely blown up by the destruction of his credibility to the point that he started getting in an altercation with a lawyer. And so you can see on the next slide, ultimately, that the judge's conclusion about him was that he was disbarred, disreputable, and so that testimony about Harry Bridges having been at a Communist Party meeting was simply unbelievable. And so what was done here with this witness was another example of credibility. I'm going to deliver to you these things, judges, and then delivering it, and storytelling. Rather than get in the weeds of Cicero's testimony, right, where Cicero was saying, on this date this happened, on this date that happened, getting in the weeds of that tit for tat, would allow the fact finder to pick one over the other. Bridges' lawyers decontextualized it from that to a higher level and said, every word this man utters can't be true because the man doesn't have credibility. He's been disbarred for jury tampering, and he's been indicted with Al Capone for fomenting violence by bomb making. Everything he says is a lie. That allows them to then cherry pick certain portions of his story that were most effective and show where he disagreed with someone else, why that someone else, Harry Bridges, had to be believed. This lets you then, as a lawyer, get to your best points in the best way by proper storytelling. Now, our final set of slides here, we're going to now go back a few thousand years. We're not going to go back quite as far as Cicero and the Roman Republic. We're going to fast forward a bit, but we're still going to go back to around the late 300s AD during the Roman Empire. And in this time, for about 350 years, the Roman Senate had an altar in it, and this was part of the general pagan rituals that the Roman Empire had conducted. Now, over time, the growing base of Christians throughout the Roman Empire had become really, really powerful, especially post-Constantine. And cities were more and more in the Roman Empire becoming close to majority Christian or majority Christian. But emperors were still persecuting Christians at times by their decrees or by turning a blind eye, and there were massive differences in terms of how Christians were treated within the legal system still. And so this altar was removed from the Roman Senate. Now, the reality, historians say, is only a few thousand people had ever seen it. It was in the Senate. It wasn't a tourist attraction, but it was symbolic of the general pagan Roman Republic, and sacrifices were done on it, at the beginning of the year and whatnot. And so it was there. But this thing had been removed because of it was inimical to Christianity. And so this provoked a battle to erupt between the Christian powers and the non-Christian Roman mayor. And what's remarkable from the historical record that we have to explore advocacy from the ancient world in terms of storytelling and credibility is we actually have the entire written advocacy on this issue of should the altar be removed, right? It's a legal question. It was their legal question. And these advocacy arguments, briefs basically, were given to the emperor to argue each side of it. And this then pitted two people from antiquity. Rome's consul Symmachus, who was arguing the altar has to be put back, we need to have the altar, and the Bishop of Milan, Bishop Ambrose. And so let's take a look at advocacy on these slides in the old Roman world from the consul Symmachus first. Symmachus was arguing to keep the altar based on the argument that we want to maintain old ways and traditions. And you see his quote here, "We beseech you, old men, to leave to posterity what we received as boys. The love of custom is great." And this is an argument, of course, to tradition, the traditional ways. That can have some appeal. He also argued that all religions can be respected, that Rome actually was tolerant of all religions. And so what he argued is, it's just that all worship should be considered as one. We all look on the same stars, the sky is common, the same world surrounds us. What difference does it make by what pains each of us seek the truth? We cannot attain to so great a secret by one road, but this discussion is rather for persons at ease. We now offer prayers, not conflict. If you think about it, it's a really great argument. I mean, it's what our republic is based on here today. He was arguing we should put the altar back because we respect all religions. Why would we be taking the altar out if we don't respect all religions? We all look upon the same stars. Then Symmachus gets to a critical argument he makes, and this is a causation-correlation argument. And this is a pitfall for many of the advocates today that we have to be very careful of. He says, I'm not just defending the cause of religion. What I'm saying is that the Roman race recently has had a lot of misfortunes. And he goes through here, on this slide, you can read the quote, and I won't read it to you, but he goes through what has happened to Rome in the last several years. And it had been a great time of turbulence when this argument was happening. There had been a famine, poor harvests, there had been some battles that the Romans had lost, and this loss of crops and corn and damage, he argued, was caused by the removal of the altar and our lack of fidelity to the old ways. And so he had, at this point, extended himself on a causation argument, ultimately, that's one that could be proved, but it could be disproved. And so here we look, how do we look at what Symmachus did? Well, we have credibility questions, right? There's this causation correlation argument on our slide 29 here that he's talking about. The other thing he did was he failed to acknowledge the historical grievance that the Christians were complaining about. They were complaining that we were being persecuted. And that was a lost concession opportunity. He didn't account for the other side's facts. It's an example, like we talked about earlier, of building a character and having that character be the one you want, which is we tolerate everyone, let's just put it back, let's have fidelity to the old ways. But that doesn't harmonize with the record. The Christians had been persecuted, and his narrative didn't account for that. Now, he did have this super powerful argument about religious tolerance, which is a great argument for the bedrock of Roman thinking. But the problem with his argument was that it implied the idea that pagan rituals equated to tolerance, but persecution again had happened. And you can't use it unless tactically you're doing your advocacy properly. So, what did the Bishop of Milan, Bishop Ambrose, say in response? Here we are on slide 30, and you can see. He comes forward and says, tolerance, you're overstating your tolerance argument. And let me tell you about tolerance. And so what he says here is that you're denying that Christ is God because you don't believe that he died for us. You're honoring, thoughtless people, but meanwhile you insult us, you disparage us. You consider your piece of wood, the altar was made of wood, to be your God. That's disparaging to us. That's not religious tolerance. And then he directly goes to the causation argument. And he says, what causation? You're talking about a few things that you've picked out. But by the way, in these other places, it's been a bountiful time. Things have been great. He was able to point to all these data points of success within the empire to completely blow up the causation argument. And so what had happened is Symmachus had extended his credibility on causation on that limb, and Ambrose just broke the limb, undermining his argument. And then Ambrose backs up this idea of tolerance by saying picking one over the other isn't tolerance, and he then goes on to point out, we've been persecuted. We don't have equal rights. You can do things we can't do, and he lists all of them that are in antiquity, and you can read their letters. They're really they're fantastic, and they're on the internet. They're available. And this is then the opening that Ambrose takes, because he still has to address the idea that we should have fidelity to the old ways, to tradition. It's great. It's important for us and our custom. It's who we are, right? Ambrose responds to that. Having deflated the causation argument, he now gets to say, hold on. We're not in decline, because the root of what Symmachus was saying is the empire's declining, things are getting bad. Ambrose is able to say, decline, what are you talking about? We're in progress, right? It's a fantastic argument. He now gets to sell something that's very hard to disprove. He's now selling the future, hope. Things are going to get better. And all the bad things that have happened recently are just steps along the way to things getting better. And so yes, things were great in the past, and they're still getting greater, and the sun has not fully risen yet. And this is the gist of what he says here in this argument. So what's the summary when you look at Bishop Ambrose, Symmachus, and effective advocacy? He confronted the weak causation argument, which was easy to dismember, and then he could inflict a blow on his adversary's credibility. Symmachus had risked his credibility, and once lost, it's very, very hard to get back. Now, Symmachus's tolerance argument was a powerful one, but because Symmachus didn't let it fully embrace the narrative, all the characters in the story, because he didn't take that opportunity to say, yes, we made a mistake, Christians have been persecuted, bad on me, let's not do that. He lost that concession opportunity, which was his ability to sell tolerance. Having lost the concession because he didn't want to make it, Ambrose had the opening to say, what tolerance? We're being persecuted. We can't even hold land, for example. Now, then this became the affirmative claim of society is still getting better, progress is ahead. That's a fantastic argument to be given the opening to make, because it's impossible to disprove with causation, right? It's future-oriented, it's hope, it's aspirational. It's what we sell today, and politicians sell, but lawyers, we're selling to our jury in our cases to that. So Those are the summary of the sort of the effective advocacy and the storytelling and credibility, which comes from antiquity, from thousands of years ago, right? I mean, 1,700 years ago that was happening. And you want to know who won, right? The altar did not go back in the Senate, and within about 100 years, Rome, the Western Roman Empire, had effectively fallen, and Christianity had become the dominant religion. And so historians can debate, I certainly am not qualified to say whether that was the pivotal or a pivotal point in that transformation. But within the four corners of that narrow case, in terms of just does the altar go back or does it not go back, from an advocacy perspective, one understood storytelling and credibility, and one made mistakes on storytelling and credibility. The winner was the one that used these advocacy principles best. So this brings us to our conclusions. To please, to prove, to move. Cicero's ideas are critical, and they're critical today. This idea of pleasing, proving, and moving is critical. And the way we get there is through storytelling and credibility. And I hope in today's advanced advocacy program, you've really come to embrace and understand and value the idea of storytelling in all aspects of lawyering, of credibility. It's that color on the tools I talked about. Everything we do is an opportunity at building credibility. Even when we have to make concessions, we can build credibility and get something back. Credibility and storytelling are the mediating principles that can sort of bridge the gap. It's the relationship between getting your strong positions and addressing your weak ones. How do you bridge the divide between those two? It's by having an effective story to tell, and by telling stories effectively, and by doing them cognizant of and valuing the critical nature of credibility. We talked about the values of concessions, and I really urge you to think heavily about Cialdini's ideas in the book Influence we talked about in terms of how you can use concessions to your advantage as an advocate, whether it's negotiating with the other side on some minimal issue about more time to respond to discovery, whether you can give a concession in a big deal you're doing, or whether you're standing before a jury and you can make a concession on something and gain currency with the jury that, yes, you're able to concede that, but in return you're subtly asking the jury for something else. Or before an appellate panel, there's nothing more valuable than where you have a weak case being able to make a concession and tell the court, I agree, Your Honor, I have that problem with my case, but it doesn't matter for this reason, where you can pivot to a different legal doctrine that can embrace and render less powerful or meaningful your weak point. And that concession gets you credibility. We looked at the currency of credibility chart, which I think is a critical chart for you to keep in mind. And it's not just a chart for appellate lawyers. It should be a chart you think about in your trial activities. The idea that in a simple human dispute, whether it's a contract claim or a battery, the idea that it could lead to 18 different claims and causes of action is an idea that itself has become overstated in the practice of law, and I think it undermines your ability to show the judge out of the gate that you're credible. And I think if you have an effective advocate on the other side, they're going to look at you wrapping this up in 15 causes of action or whatever, these innumerable claims that are now being brought on simple claims. Defense lawyers will look at that and say, this person doesn't really know what they're doing. They don't have credibility with me. How could that be good for you as a lawyer to not have credibility with opposing counsel who you want to find a resolution to your case, right? You hurt your client. Know your audience. This is one of the final points here on our conclusion side. You need to tailor carefully your message to the specific audience. So you always need to understand who your audience is so you can tailor that message with credibility, right? Your story may be one that's rooted more in emotion for certain audiences than others. It may have varying degrees depending upon who your audience is, but you need to know your audience so you can tailor the message. And finally, let's go back to some of those principles we started on. The specifics of having knowledge, candor, logic, emotion, and critically, eye contact. Look at the people you're talking to. Don't always look over their heads. Make eye contact. If you're talking to a jury of 12 people, at some point make individual eye contact with each of them. You, the juror, you're focused on them. You hear them. You see them, right? Same with the judges. When you're speaking to the judge, look at the judge in the eyes. When you're talking to your judges on appeal, look at all of them in the eyes. Anyway, those are the tips and principles that distilled from this overall presentation on advanced advocacy, as we've looked at cases from the Cold War, the famous Harry Bridges trial from my book Burning Bridges, to ancient Rome, to Cicero in the Republic, and to the fantastic story of the Bishop of Milan and Symmachus in the Roman Empire period. I hope you found these advanced lessons on advocacy valuable. I love to hear from people, so emails, questions, feel free to reach out to me anytime. I always respond. Have a good day.